Let's come to order. So this is a panel on race and the American death penalty. We've got a wonderful set of speakers. The speakers have arranged themselves in order. Let's proceed.
All right. My name is John Bessler. I have written a lot of books about the death penalty. I always joke that I do winter reading as opposed to summer reading. I'm working on a book right now on actually the death penalty is torture, which I might say a word about at the end. And because so much of my writing is directed at the Supreme Court, my audience is 9, but now it's down to 8, so I've lost part of my audience. I want to thank Carol and Jordan for inviting me to be here today. I've been thinking a lot about recently the issue of equality as well, and inequality in the death penalty. And these issues are very intertwined, the death penalty and race, and particularly racial discrimination. And if you look at the words on the Supreme Court building, equal justice under law, we have not seen that be realized. In colonial America, slaves were not only executed, but they were subject to horrible forms of execution, burning at the stake. There was a case right in Massachusetts here in 1755 where 2 slaves were executed for planning to poison their master, and the woman was burned at the stake, and the man was Mark, was the name of the slave, was gibbeted, and his body was hung in chains for a couple of decades. And actually, when Paul Revere did his famous ride, the body was still there, shriveled up. And so the history of the death penalty cannot be separated from slavery. In fact, the use of executions to quash slave rebellions and the fear of slave rebellions was what drove a lot of the use of the death penalty back at that time. I actually ran across a case where a slave was not actually executed but was lashed, I think, 29 times. And then at that point, there was a collar placed around the slave's neck. If the slave ever left his plantation again, he was to be hanged. And so the threat of execution was ever present in colonial times. Of course, in the Declaration of Independence, we have this promise of equality. Now, then it was for all men. They excluded women. They excluded African Americans from the social compact. But Gabriel was a slave who was born in 1776, and he was involved in a slave rebellion in Richmond, Virginia, and he had planned to have a group of slaves gather together, take over the Capitol, take over the penitentiary, take over the armory, and was going to march behind the banner of death or liberty, kind of the converse of the Patrick Henry famous speech, liberty or death. And he was hanged along with 2 of his brothers and over 30 other slaves participating in that rebellion. There was actually an exchange of views between James Madison and Thomas Jefferson about when to stay the hand of the executioner. And this was the debate. And after so many executions, they both concluded that enough slaves had been hung, but there was enough slaves hung to presumably try to put down any other potential slave rebellions, at least in their eyes. Gabriel had been involved in a dispute with a former landowner before that, and had bitten off the ear of the landowner in this dispute, and was branded instead of being executed. But he was later, as I said, executed in this rebellion, which took place in 1800. Actually, one of the most interesting things I found in doing a book on the history of the Cruel and Unusual Punishments Clause is that there's actually a close association with slavery and the words that we have in the Eighth Amendment, the Cruel and Unusual Punishments language. You find laws in South Carolina, for example, which prohibit the punishing a slave with unusual rigor. You find laws in various southern states that prohibit the cruel or unusual punishment of a slave. Now, this was not to protect the slave. This was to protect the property interest of the slave owner. But the very words in our Constitution have this tie back to race and back to slavery. Now, of course, we all know about Dred Scott, but early laws in the United States actually prohibited African Americans from even testifying in court. And we, of course, had the Civil War, the Emancipation Proclamation, and the 13th Amendment, which abolished slavery and involuntary servitude. And then I was looking back at some of the history in preparation for the conference, and actually one of the things that was done after the 13th Amendment was the Civil Rights Act of 1866. And just to share with you some of the language from that, it said that Section 1 provides that all persons born in the United States are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, shall have the same right to full and equal benefit of the laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties. So the Civil Rights Act of 1866 expressly contemplated that there would be like punishment as between whites and blacks, and then Section 2 provided a mechanism to enforce that and spoke of if there's different punishment, then it would be a misdemeanor. The maximum fine would be $1,000, imprisonment not exceeding 1 year, in the discretion of the court. So the Civil Rights Act of 1866 was a very foundational act. There was some thought that maybe Congress did not have the authority to put these kinds of laws in place. There was a lot of debate, even among Northerners, that maybe the Congress had overstepped its constitutional authority in putting that in place. And so what happened was the 14th Amendment came about. And the 14th Amendment, the U.S. Supreme Court and other commentators have said, was intended to put into the Constitution this idea of non-discrimination and also this idea of equalizing punishments. Now, the reaction, of course, in the South, which had always had laws that treated blacks and whites differently, these slave codes, was to enact what were called the black codes, which actually provided for different punishments for whites and blacks. Frederick Douglass actually, in a speech he gave in 1852 in New York, noted that in Virginia there were 72 crimes that were punishable by death for blacks. There was only 2 such crimes for whites. So dramatic differences. But the Supreme Court, in the case of Jett versus Dallas Independent School District, a case from 1989, actually said that many members of the 39th Congress, which we're talking about the 14th Amendment, viewed Section 1 of the 14th Amendment as, quote, constitutionalizing and expanding the protections of the 1866 Act, which, remember, talked about like punishments. And so I think that's a very important thing to remember of how we got the 14th Amendment. The 14th Amendment, everybody knows about Brown versus Board of Education. We've seen the implementation of the 14th Amendment in the context of public education, but we really have not seen the application of the 14th Amendment in the context of punishment, which was one of the specific purposes that the drafters of the 14th Amendment had in mind following the Civil Rights Act of 1866. The 14th Amendment was ratified in 1868. I looked back at some newspaper articles. There was actually an open letter that were written by, they described themselves as colored citizens of Charleston, South Carolina, making an appeal to their fellow citizens. And they described the Black Code as a disgrace to civilization and noted that it imposed penalties on us, which were not imposed on white men. In the New York Times, they talked about Georgia's old slave code, and they said that black codes were enacted as cruel, as unjust, and in all respects as infamous as those which disgraced the days before the war. So, thinking about that idea of equalizing punishments, the Supreme Court again weighed in 1883 in a case called United States versus Harris, and said that Congress has, by virtue of this amendment, enacted that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts. That was another aspect of the Civil Rights Act of 1866, and shall be subject to like punishment. So again, the Supreme Court, well before McCleskey, which is the case we'll talk about in a second, which is part of the modern challenge to the death penalty, in which the Supreme Court rejected the use of statistical evidence that was put together by David Baldus and others to show that the racial discrimination that was existing in Georgia's death penalty. The Supreme Court rejected that and said that the person putting it forward had to show discrimination in that case. In his case, he had to show the purposeful discrimination. If you look back at lynchings, we have a whole history of lynchings, in particular lynchings in situations where African-American men were accused of sexually assaulting white women. Thousands of lynchings that took place in the South. The Equal Justice Initiative just did a big report on this topic, documenting literally thousands of what were called racial terror lynchings that took place in southern states. I once did a book on a lynching that took place in Duluth, Minnesota. It wasn't limited to the South, but discovered there that people actually used to send postcards out. They'd pose in front of the body of the lynching victims and distribute those. The last public execution was in Owensboro, Kentucky, and 10 to 20,000 people gathered to watch a young African-American man be hung for killing a 70-year-old white woman. And Michael Meltzner did a nice job talking about the NAACP's challenge, and a lot of this was focused on the issue of rape and the death penalty. And actually, one of the things that people forget is actually the anti-lynching movement developed also as part of the NAACP. When I was researching this lynching that took place in Duluth in 1920, I found that they were soliciting $1 contributions from various people to fund this movement, which I found quite touching to see this list of different people doing that. But the challenges to the death penalty really start right in the 1960s. Actually, Justice Arthur Goldberg tried to convince his colleagues in 1963 to basically declare the death penalty unconstitutional. He was unsuccessful, but there was a case in 1963 called Rudolph versus Alabama where he raised questions about whether or not the death penalty should be applied to those who had not killed anybody but had raped. And race was an issue that really suffuses that entire context. And so, of course, in Coker versus Georgia, another Georgia case, the Supreme Court later said that non-homicidal rape could not be punished by death. One of the things that I think is most troubling is the way that the Supreme Court reads the Cruel and Unusual Punishments Clause and the evolving standards of decency. They take into account legislation and jury verdicts, but yet they allow death qualification of the juries, which results in a large number of African Americans being excluded. You end up with often all-white juries or near all-white juries. And then that is the data that the Supreme Court is considering when they're determining the constitutionality of the death penalty. And the Baldus study, of course, as we all know, found a lot of racial discrimination based on the race of the victim and just huge disparities in treatment. So I think one of the things that, in McCleskey and in Furman, we have a couple of cases. We have in Furman that a lot of the judges that had concurring opinions in that 5-4 decision talked about the racial discrimination present in the system. In McCleskey, Justice Powell, and it was a 5-4 decision, wrote the majority opinion, but then later, after he retired, said he regretted his decision in that case. In fact, in all death penalty cases, he would have voted differently. The project I'm working on right now is actually thinking about the death penalty as torture, because right now, under international law, it's very clear that mock executions are a classic example of psychological torture, and the Supreme Court's lethal injection jurisprudence, unfortunately, has focused only on whether at the very moment of death there will be excruciating physical pain associated with the execution. And if a fake execution is already considered to be psychological torture, one has to ask whether or not a real one would also qualify as such. And the severity of the punishment is something we need to be thinking about as we think about the death penalty, because as you find lethal injection, the masking that was talked about earlier of the violence that's associated with that, you think about that. And under international law, torture is already considered to be what's called a jus cogens norm. It's an absolute prohibition. You can't torture anybody during time of war or public emergency. And if we think back to the idea of universal rights, if torture is a universal right, if we allow everybody to not be tortured except those who have done terrible things, then we truly don't have universal rights. that the concept of torture, if you have universal rights, and the rights to non-discrimination, the right to human dignity, the right to be free from cruelty and torture, these are all universal rights. And if we don't protect them in all cases, then we don't have universal rights. And that was the whole idea of the Universal Declaration. So I know we've got some great panels to talk about updated, but that gives you a little bit of the sense of the history of how we got to where we are today.
My name is Mike Radlett. I'm from the University of Colorado. It's always great to be at Harvard. I went to Purdue, and it's a public school, and our most famous alumnus is Orville Redenbacher. I highly recommend his popcorn if you'd like to try some. But when you come to Harvard, it's just the who's who of everybody. I'm looking forward to meeting Elle Woods later on today, and I want to introduce a couple of people. One thing in the book, in the acknowledgments, Jordan and Carol say 3 scholars who are no longer with us were especially influential in the development of this book, and then they first name Hugo Adam Badeau. And Hugo's wife, Constance Putnam, is here. Raise your hand, Constance. What they say about Hugo is that he put the death penalty on the map as a subject of serious scholarly investigation. And that's true. He died 5 years ago after a career mostly at Tufts, doing all sorts of death penalty scholarship. One of his first, earliest works was with Sarah Ehrman in 1962. She wrote an essay called For Whom the Chair Waits in Federal Probation about erroneous convictions. And Hugo assisted Sarah. Sarah's husband, Herbert Ehrman, was one of the counsel for the Sacco and Vanzetti. I don't know, Carol said most people haven't heard of the Scottsboro Boys. Maybe they haven't heard of Sacco and Vanzetti. But in any event, this has ties way back to the 1920s. So Hugo began that, and then throughout his career published a number of different essays and books on erroneous convictions. And in 1992, Constance and Hugo and I were able to collaborate on a book called In Spite of Innocence. So Constance has been a good friend for many, many years and an ardent abolitionist. My wife Lisa is also here. We met when she was at the Texas Resource Center. I went in, and I always have a red pen, and it always bleeds. So it was like all over. It just like knocked her socks out. I mean, she was really. Anyhow, we talked about this chainsaw massacre guy case she was working on, and I told her that I had Ted Bundy's ashes in my closet, so it was love it, immediate love. Glenn Pierce is here from Northeastern. Glenn and I have collaborated on, 20 or 30 different papers on race and death sentencing. The most recent we finished last week on a study in Oklahoma. And our friend Jackie is here from Gainesville, Florida. Jackie's been a really close friend and supporter for 30 years. Her husband, Alan Agresti, I met in 1979, and every paper that I've published that uses numbers, I've consulted with Alan. He's now retired as a statistician from UF, but hired as here at Harvard to teach an adjunct course. He's really world-renowned and has used a number of our examples on race and death sentencing in his statistics books, and therefore has been the only statistician criticized for writing statistics books with a liberal bias. So, who would have thought? I want to go through, since Glenn and I are the only two empirically based sociologists, social scientists in the room, I want to just talk a little bit about facts and figures. We know that in the years before the Furman decision, there were only 30 cases in the United States where a white person was executed for killing a black. There's never been a white person executed for the rape of a woman of color. At the time of Furman, we know the statistics well. Between 1930 and 1967, there were 3,859 people executed in the United States, 54% were African American. The racial disparity especially evident for rape, 405 out of 455 were black men, 90%. If we look only at executions for homicide, 51% of those executed between 1930 and 1967 were African American. And then if we look at the Legal Defense Fund's most recent data on who's on death row in the United States, we find that relevant proportion has changed very, 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 very little. As of July 1st, 2016, they report that among the 2,900 people on death row in the United States, 42% are white, 57% are minority. The one thing that's changed is now minority. It's not only black, it's black, Asian, Hispanic, Native American. But the relevant minority population, 51% pre-Furman of those executed for murder, we can compare that today, 57% of those on death row are people of color. So the racial disparity, at least at that one, that first cut, seems to be been increased rather than decreased. If we look, of course, the big problem is executions along the lines of race of defendant. The Department of Justice recently came out with 29 years of data on homicide victims. They report that 50.3%, 50% of the victims of homicide in the United States are white, 47% black. So, basically it's split down the middle. When we look at the executions, this is the execution list from 2016. There have been 18 executions so far this year. Georgia leads the way, I think, because Steve Bright announced his retirement. They're kind of gearing things up there, just what he needs. Georgia and Texas. But if you look at the race of victim of those 18 cases, white, 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 Latino, white, 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 all white, one Latino. So even though blacks are 47% of the homicide victims in the United States, we're getting these patterns. What's the probability if you have a bucket of marbles, half are black, half are white, picking out 18 white ones in a row? The statistical probability is zilch. So that's basically the problem that those of us who do empirically based race research have been looking at. We try to cut the pie where we only take out felony homicides, or we only take out homicides between strangers, or we only take out multiple murders, and no matter how they cut the deck, that racial disparity does not disappear. Glenn and I have also gone back, and a lot more work on this needs to be done to look at racial differences in case construction. We talk about how the death penalty is supposed to help families of homicide victims. In 1960, in the United States, 94% of homicides were solved. 1976, at the time of Gregg, it was 76% of all homicides were solved. It's now gone down to 62%. So basically 4 out of 10 murders in the United States, they never arrest the culprit. And these disproportionately, as I say, the homicides disproportionately affect African Americans. So Glenn and I looked at a data set. We looked at 164,000 homicides in the United States and found that of all those homicides, about 3/4 of the cases with white defendants were solved, or resulted in an arrest. Only about 60% of those with black victims resulted in an arrest. So the police investigation from day one tends to be more vigorous, and they're more likely to arrest a suspect when there's a white person murdered than when there's a black person murdered. And then a few years ago, we hired a guy to look at police records in Shreveport, Louisiana, which is a fun area to study. And this guy went in and he pulled data. He pulled all the police files, 430 cases in Shreveport, and we just had him count the pages in the files. And sure enough, when a white person was murdered, the files were pretty thick, especially if it's a white woman. And when a black person is murdered, those files were thin. So a direct correlation between just the number of pages in the prosecutor's file, which we use as a proxy for prosecutorial effort, put into the case. I think that one of the invitations that these race issues extend to us is to expand on the falling support for the death penalty in generally. How can we use the race argument to continue that erosion of public support? Many of you know that the Pew Research Center came out with a study last month or September. Support for the death penalty, the lowest in more than 4 decades. This was just a survey that did death and life. It didn't say life without parole. But we know that public support is dropping, and we know that it's largely because of the innocence card. And the innocence card, I think, has direct effects. You know, there's a group now in California doing a lot of work in California. They're headquartered in Philadelphia, called Witness to Innocence, which is a group of about 40 of the 156 people who have been on death row and been exonerated. And when you meet an exoneree like this, or hear their story, or even see it on film, there's a film about this that was at the Fort Lauderdale Film Festival last week, and next week will be at the Santa Fe Film Festival. It's just coming out, where these exonerees tell their stories. Direct effect, you hear the story, support for the death penalty drops. There's also it requires a rebalancing. You know, one of the critics of the innocence research has always been, well, you know, yeah, every once in a while an innocent person gets it, but on the whole, there's a net benefit. Everything we do, innocent people die. You know, we drive a car, innocent people, but there's a net benefit. And in the net benefit of the death penalty is supposed to be in deterrence. But obviously, I think that if you're doing a fair analysis of the death penalty, racial disparities plus innocence are arguments against the death penalty that even the most ardent supporter of the death penalty needs to come to grips with. So the innocence issue has really forced this rebalancing of pro or con on the death penalty. And the final effect is indirect. Do we really get the worst of the worst? Georgia's going to have another execution the first week of December, domestic homicide. A guy who was executed Wednesday night in Georgia, domestic homicide. One victim case. Are they really the worst of the worst? I mean, that's a question that that racial disparities raises. You know, we're not getting the worst of the worst because it's infected by racial disparities. I want to tell a story of one case that several times today we've already been talking about how specifically race has not been an issue raised by the Supreme Court in the Furman decision, in the Gregg decision, Maxwell v. Bishop, Coker v. Georgia. You know, they never talk exactly about race. And I just want to tell one little story. Steve Bright knows this story, but this is a case that I testified in Bartow, Florida. When you go to Florida, you don't go to Bartow, but it's down near Lakeland. It's not the hotbed of Florida tourism. And I was asked to testify at the penalty phase of a retrial for a guy named Tony Peake in 1984. Students will love it. This is the way that we used to do computer stuff. Man, these chi-squares, boy, whoo, they are really neat. But in any event, I did a little thing on race and death sentencing in Florida. Went down to testify at this case. Look, here's the bill. I billed him $500. Big bucks at the time. So I went down for the penalty phase and watched as a new judge walks in and introduces himself to the jury, saying that Judge Schmuck was gone, he's going to take over the penalty phase. And it turns out the reason that Schmuck was gone is because he had described the family of Mr. Peake by the N-word. And the defense attorney asked that judge recuse himself, which he did, and then the new judge came in and sentenced Mr. Peake to death for the second time. So it goes up to the Florida Supreme Court. They throw out that second death sentence. But I just want to read to you at the end of their decision after they threw out the conviction and death sentence. They say, although we find the collateral crime evidence was prejudicial in this case and should have been excluded, we reject appellant's contention that absent this evidence, insufficient evidence exists to sustain the conviction. We need not discuss the other issues raised by the appellant with the exception of one matter. This is the last paragraph of the decision. For future guidance to the bench, we believe that we should address the circumstances requiring the original trial judge in the case to disqualify himself after the completion of the guilt phase of the trial. That disqualification resulted from comments made by the trial judge immediately after the appellant was convicted and as the trial judge and attorneys were discussing procedure for the penalty phase. The defense attorney stated that the trial judge commented, quote, since the N-word, mom and dad are here anyway, why don't we go ahead and do the penalty phase today instead of having to subpoena them back the cost of the state. I mean, forget the today reference. Things have changed in Florida. Usually now at least you get a few days. But anyway, another person heard the comment as, quote, since the N-words are here, maybe we can go ahead with the sentencing phase. As a result of these comments, the defendant moved to disqualify the trial judge. The trial judge disqualified himself, blah, blah, blah. Then one more paragraph. This is the final paragraph of the decisions. Peake versus State, 488 Southern 2nd, 52. The Florida Supreme Court writes, trial judges must not only be impartial in their own minds, but also must convey the image of impartiality to the parties and the public. Judges must make sure that their comments both on and off the bench are proper and do not convey an image of impartiality to any person or any segment of the community. This type of conduct is required of our judiciary because, and then they quote another case, every litigant is entitled to nothing but the cold neutrality of the partial judge, blah, blah. We write about this incident to emphasize the need for all judges to be constantly vigilant about their comments and demeanor both inside and outside the courtroom to assure the impartiality of the judiciary may not be reasonably questioned. That's it, as long as you don't use the N-word. And the culmination of that case is came a couple years later. Here's the Tampa Times Tribune. Convicted rapist exonerated of 1977 rape. It came back and he was acquitted at his retrial. So race and innocence, that intersection, I know of no better case that illustrates it. So I just want to say one thing in conclusion about our collective depression. And I remember Bob Sullivan was executed in Florida November 30th, 1983. He was the first death row inmate who I had gotten to know. And we were outside the prison during the execution. This is what, 30, I don't know. I go to a public school. 34 years ago, something like that? I don't know. And somebody came up, I don't know who it was standing next to me, but a reporter came up and said to the person standing next to me, what are you doing standing out in the field, protesting this execution? Do you think you're going to change the world? And this person said, no, we don't do this to change the world. We do this so that the world doesn't change us. Great line. Thank you.
Okay, thank you. So I also want to join my fellow panelists in thanking Jordan and Carol for inviting me to speak today. It's a privilege to be here and share the stage with these extremely, extremely smart folks. So I want to talk a little bit about contemporary litigation of capital cases and what we do with race and how race and this history of racial discrimination in the administration of the death penalty continues to play out in these cases. When we talk about race and the death penalty, you hear about the lynchings and you hear about the amazing information that we heard from this morning about the connection to the slave codes and slavery. And so, and we're invited when we are, as litigators, put together a case to challenge racial discrimination in the administration of the death penalty, to look at what's happening right now and get the statistics about, comparisons and who, the pool of possible people that might have been charged who are beside your client at this moment. And it invites the idea that all that happened in the past really doesn't play into the cases today. But my work really suggests something otherwise, and I think that that's what I want to talk about today. I'm going to talk about one case, or at least one place where we are litigating a case to demonstrate how the history of racial discrimination in this country continues to play a very real and corrupting role in the structures through which capital cases are litigated. And so that is recipe formula for what I'm going to talk about. So, the idea, of course, is that the past is never dead. It's not even past, right? That's William Faulkner. And in this conversation, right, it is the original sin, is the original stain of race in this country, which we cannot get past. And certainly we cannot get past it in the context of capital cases. LDF has been litigating a capital case in Pine Bluff, Arkansas forever. I won't tell you much about the case. It doesn't matter, other than it's an African-American client who convicted of killing a white guy in an ATM robbery in Pine Bluff, Arkansas. So Pine Bluff is about 40 minutes outside of Little Rock. And you can see these are some of the statistics about the place. You know, it's a county which is predominantly white, but the city is predominantly African American. That is a photo of the Jefferson County Courthouse, which will become relevant as I go along and tell the story of this particular place. So Pine Bluff and Jefferson County has, like many places in the South, a significant history of racial terror. When we go into these cases at LDF, we sort of meet with folks in the community and learn not just about the case at hand, but about the history of the jurisdiction in which we are litigating, because we think an understanding of where we are litigating is imperative to understanding how our cases will be perceived and were perceived at the time of trial. And so as we sort of dug into the history of Pine Bluff, we came up with this tidbit of information. And so I'm going to sort of I'm not going to tell the story in the order in which we learned it. I'm going to tell it sort of chronologically, and then maybe I'll explain how it all comes together. I think it'll become clear. So Eric Foner is one of, the country's foremost historians. I gather I don't have to tell people here who he is. He has this book on Reconstruction, and he finds, and in his research, that in 1866, after some kind of dispute with freedmen, a group near Pine Bluff, Arkansas, set fire to a black settlement and rounded up the inhabitants. A man who visited the scene the following morning found a sight that appalled me. 24 men, women, and children were hanging to trees all around the cabins. So this is where our story of Pine Bluff begins, right? 24 men, women, and children went in the trees in one night in Pine Bluff. That sort of was bone-chilling for me. Makes the hair, on my arms stand up, and you think, like, what kind of place does, what happens to a place where 24 people get lynched in one night? So we learned. So we, learned that, of course, that was the beginning of the story of lynchings in Jefferson County and Pine Bluff, and any historian that has looked into the research around lynchings will tell you that this is what we found. This is undoubtedly a inadequate and incomplete picture, because nobody, the reports of lynchings are inadequate all the time, but this is what we found. So there's about 8 of them, aside from the 24 that follow, and the 2 in the middle that are bolded are not just the same year, but the same night in 1862, and this is in 1909. We have another time. See, it's not even on the list, I think. No, there's another one, yes. So 1909, this is the New York Times headline, while the dusky murderers are swung up to the cross arm of a telegraph pole in the glare of the electric lights, a strange scene for people returning from church. Again, this is Pine Bluff. The 2 who go up, who are lynched in 1892, are lynched in front of the Jefferson County Courthouse on a light pole. And this figures prominently into the narrative that we learn in this community. So this is deeply embedded in the history. But again, right, you think to yourself, well, this is a really long time ago. So when you look at the way back history, you find out, not surprisingly, given all of this history, people are fleeing, right? Black people are trying to get the heck out of Pine Bluff, Arkansas, because it is obviously not a safe place. And so we found sort of articles documenting what you would expect, what I would have done, right? Anybody with means and capacity that was living in that place at that time would have, hightailed it out of the area. Indeed, we find that history. The life went on, and there's still, as you saw from the stats, a lot of African Americans stayed in the area, and so. Jim Crow happened. Civil rights movement may or may not have happened in Pine Bluff, but things went on. But the Pine Bluff that you would learn today is, deeply segregated. There is significant unemployment and underemployment of the African American community. There is, lots of problems in the educational system. All of the things that are a byproduct of the racial discrimination. I'm not going to run through it all. Oh, I should say, right. So this is the map of Arkansas's lynchings. Number 8, Jefferson County has 8 lynchings, which is not right because it doesn't include the original 24, but it puts, Jefferson County way off on the top 10 of lynching counties in Arkansas. We are in a bad, bad place. So we fast forward in the life of Pine Bluff. And so, it's not just lynchings that happen, right? All of sorts of just racial discrimination occur in this place. And so LDF comes in the late 80s and early 90s, and we're doing some voting rights work in Arkansas. And what we do, and we still do to this day, is we bring, voting rights challenges against sort of at-large voting structures which preclude the Black community from electing candidates of choice, right? And so Hunt versus Arkansas is one of these cases where we challenged the state's at-large voting structure for judges, saying that, obviously because African Americans were a minority in the community, they were pretty much precluded from having any African American judges. This was a successful lawsuit. So we challenge it. We bring they have this at-large system. We bring the lawsuit, and a district voting system is ordered by the courts, and so African Americans are able to elect the candidates of their choice. Now, let's bring Hunt versus Arkansas, which is a great win, we thought, to Pine Bluff. And this is what they created there. So they did, in fact, create a seat for an African-American judge in Pine Bluff in Jefferson County. So there was none at that time. And so then they created a seat for an African-American judge. So this is a little bit backwards. But so that Black judge, so if you read the chart sort of backwards, that Black judge then staffed his courtroom with largely a Black court staff, and in the time of our case, which was 1993, the court staff was largely responsible for pulling in the jurors. So the Black court staff in the Black judge's room would bring in and make sure to include Black jurors in the process and would be for consideration in capital cases. Then there was the white judge. And the white judges, I should say. And the white judges also had completely white court staffs, and so the white court rooms, you pretty much had Black people excluded from the jury system. And this is all, we had a statistician come in, and there's actually sworn, and here's the shocking part, without any objection or contradiction testimony to all of this. Let me just make it clear. We presented this, and without a blink of an eye, everybody just said, oh, yes, okay. So in addition, we have what I like to call Black court and white court. And in addition to the Black court and white court, they then needed they had to have public defenders, right? They had previously had just solo practitioners, but then they decided that they were going to have appointed counsel serve as the public defenders, and they had 2 firms. One was all white, and one was all Black, and they served as conflict counsel to each other. And then they staffed, of course, the white public defender to the white judge, and the Black public defender fed to the Black judge. And so, your client, if you had an African American client, would really prefer to go to Black court because they had a far better chance of a success than going to a white court. I could regale you about the differences between these 2 public defenders, but I don't have the time. Okay, so that is literally how the system of justice in Pine Bluff worked in 1993, thanks to LDF's fine work with that Hunt versus Arkansas lawsuit. Okay, but that wasn't enough, right? So capital cases go through this process, and in the course of jury selection, which, as we know, is critically important, we wanted to figure out how that happened. So we interviewed a gentleman who was the first African American prosecutor in Jefferson County, and others who all offered sworn, unopposed testimony on this basis. And we said, talk to us about jury selection in Pine Bluff in 1993, and this is what he testified. This is from the perspective of the Jefferson County Prosecuting Attorney's Office. Quote, "Your perfect juror was a Black person who was over 60, lived in a segregated society. The prosecutors thought they were predictable. They were used to taking orders from white people, or at least not standing up to white people. And if you had a jury with 11 whites and 1 black and an elderly black, the prosecutors believed that 1 black person was not going to buck those 11 white people. And that was pretty much true. We went on and said, so how would they know? Like, how could you possibly figure out who this, this particular black person was? And he testified, the prosecutors knew them from the community. They worked at the country club. They were someone's maid. They lived on somebody's plantation. They pretty much knew what they were getting. And so we went on and kept the questioning goes on. And we said sort of like, how does this work, right? Why would anybody feel like they have to do this? And he testified, quote, black jurors had a fear of serving. They had a fear of if you made a decision that displeased the white community or the white power structure, that some type of retribution. I just want to just reiterate, we are talking about 1993, right? This is 1990. This is, the year I graduated from law school. This is, relatively contemporaneous for capital cases, certainly for those of us that do appeals and post-conviction work. And then he went on this point, which was astonishing, right? Black people had a fear of serving. And then he said, well, there were black people who, again, remember coming out of segregation, you had laws on the books that said a black person couldn't serve on a jury, couldn't testify in court, depending on how far back you want to go. There was no history in this county and most counties of black people having served as jurors. In general, and I'm going back now to the 70s, the courthouse was a bad place for a black man to be. So people didn't want to come to the courthouse, didn't want any contact with law enforcement officers, fearful of, prosecutors. We ultimately had multiple people testify to this phenomenon about people in Pine Bluff, African Americans, being afraid to come into the courthouse. And we said, was it just as a witness, just as a defendant? No. To serve, to get a marriage license, to get whatever, to register a deed. No one was trying to walk into the door of the Pine Bluff courthouse. So what did this turn out to mean? So we have this crazy segregated system, and we have this jury selection process. So for our case, it meant that 2 co-defendants, one went to the black public defender, one went to the white public defender. The shooter goes through black court and gets life without, and our non-shooter goes to white court, for want of a better phrase, and gets death. So the Supreme Court will tell us that this long ago history about, right, the lynchings in front of the Pine Bluff courthouse, right, where now people say is not a safe place for a black man to be. Maybe that's not contemporaneous, right? McCleskey, the Supreme Court says, unless historical evidence is reasonably contemporaneous with the challenge decision, it has little probative value. That's the current law. Although the history of racial discrimination in this country is undeniable, we cannot accept official actions taken long ago as evidence of current intent, right? This story, and I don't think this is novel, right, really sort of takes issue with that assumption, right, that the long ago history no longer is playing in today's functioning of certainly capital punishment, but not just capital punishment, because this, of course, comes up significantly in the Voting Rights Act litigation that has been going on and is going to go on some more. In the Shelby County case, Justice Roberts wrote, this is 2013, when striking down a critical piece of the Voting Rights Act, he says, history did not end in 1965. He's saying whatever happened over there is over there. By the time the Voting Rights Act was reauthorized in 2006, there had been 40 more years of it. And yet the coverage formula that Congress reauthorized in 2006 ignores those developments, keeping the focus on decades-old problems rather than current data reflecting current needs, right? He says what happened that's McCleskey again, what happened back in the day happened back in the day, and that has nothing to do with what we're doing now, which I think is false, and certainly in the context of the death penalty. Justice Ginsburg, as she does, of course, comes with a different perspective on this issue in the voting rights case. And she says voting discrimination has evolved into subtler second-generation barriers, and consideration of the long history of voting discrimination still in living memory was altogether appropriate by the district court that considered it. The court criticizes Congress for failing to recognize that history did not end in 1965, but the court ignores that what is past is prologue, and those who cannot remember the past are condemned to repeat it. And I think that's as true in the voting rights context as it is in the capital punishment context. And I will end on that note. Thank you.
Good day, everyone. I'm Steve Bright. I'm not retired. I'm not planning to retire. I will never retire. Don't believe it when Mike Radlett says I retired. And he's from Purdue. I'm from Kentucky. Our famous leading citizen is Colonel Harlan Sanders. So before you eat your popcorn, you can get a little fried chicken. I want to talk a little more generally about, just to pull together some of the things we've talked about here. The one thing I think is very important to understand is that of all the institutions in the United States, the criminal courts are the institutions that have been least affected by the civil rights movement. When I travel around the South, and I have for the last 35 years, litigating mostly death penalty cases in Alabama and Georgia, Mississippi, Louisiana, those states, a lot of things have changed. There are now people of color in the legislatures and on the school boards and in the county commissions and the city councils. The person who was almost beaten to death at the Edmund Pettus Bridge is now my congressman, John Lewis, and one of the more respected members of Congress. A lot of things have changed, but I go to the courthouse and nothing has changed. I might as well be back in 1940 or 1950. The judge is white. The prosecutors are white. The court-appointed hacks, lawyers are white. And even in communities with very substantial African-American population or other minority populations, you look at the jury box and every single person on the jury will be white. And people in that community will come into the courtroom, a community 25, 30, 40% black, and they'll come in and they'll sit in the gallery and they'll look up and say, how could it be that a jury from this community could not have any members of our race on the jury? And I'll get to that in a moment. I think this mention that John and others did of the history is so important because we want to pretend that that was then and this is now, and sometimes somehow there's an iron curtain between the Civil War and all the things that went on. But the role of the criminal courts in racial oppression is constant. From the reason the South, of course, is the death belt is because of slavery. Slaves were already imprisoned. You couldn't imprison a person who was a slave. So the only punishment that really mattered, and of course was a great deterrent because part of it was to punish that person and part of it was to scare the rest of the people, was the death penalty. So you could get the death penalty for distributing leaflets in Louisiana. And of course, as has been talked about, different crimes for black and white. And then after the Civil War, to go to convict leasing, where so many people, and we're talking about what people know and don't know, and know the Scottsboro case or not. I teach in my class convict leasing. The fact that black people would be arrested on any kind of charge, loitering, whatever it might be, not having papers, not being in the right place at the right time, whatever it might be, and then leased out to the turpentine camps, to the plantations, to the railroads, to the coal mines around Birmingham, Alabama. And as David Oshinsky said in his book, it was worse than slavery because at least slaves, there was a property interest in the slaves. But with leased convicts, you could send them into the coal mines, these primitive coal mines around Birmingham, and when the coal mine collapsed, well, you just call the sheriff and lease some more. These were disposable people. You had no great need to give them decent food, to give them medical care, to treat them like human beings. Blackman writes in his book, Slavery by Another Name, tells the story of convict leasing in Alabama, that Alabama perpetuated slavery all the way until World War II. Most people thought slavery ended with the Emancipation Proclamation, at least in the occupied part of the United States. It didn't end in Alabama until World War II, and that was because of the criminal justice system. And the same thing for Jim Crow, for this racial caste system that was enforced by the court system. And then, of course, lynchings, which took place, and of course were terrorism. That took place in the country. Today we passed a terrorism bill just like that. Back in those days, Richard Russell, a senator from Georgia, managed to keep Congress from ever to this day, there's never been an anti-lynching law passed by the Senate of the United States. And that's because Richard Russell, using the same arguments that are used today, states' rights, federalism, comedy, all these things. These are important things. Leave it to the states. Richard Russell would go home to Winder, Georgia, and a couple of people would be lynched there. And then he would come back to Washington and say, don't worry, we have it under control. This is just a matter that the racists can work out within the states. And then, of course, the legal lynching, when lynchings moved into the courtroom. And we started having the perfunctory death penalty trial. And the Scottsboro case being a prominent example of that, the people in Scottsboro saying, what in the hell are you complaining? These kids got, day-long trials before all-white, all-male juries where the outcome was a foregone conclusion. Well, we used to lynch them. We didn't lynch them. There's actually a case in Kentucky where they gave the guy a 1-hour trial and then hung him right after the trial, right behind the courthouse. And the Courier-Journal, the newspaper there, wrote an editorial that said, well, it's pretty bad and it's pretty fast, but at least we didn't lynch him. We had, so this notion that procedure, that if we give people just a little bit of procedure, and you have the people saying, let the law take its course, because everybody knew what the law was going to be. These people are going to get a perfunctory lawyer, they're going to get a perfunctory trial, and they were going to get the death penalty, and they were going to get executed. And of course, back in those days, they got executed pretty quickly. We go right on into today, mass incarceration, where again, I go to courts where it's amazing how they'll put people on, probation in felony cases. These cases don't plead down to a lesser. They'll let them have a felony because it's going to disenfranchise them. You're going to get out today. You don't worry, plead guilty. You'll get out today. You'll never vote again, but you'll get out. And we will impose conditions you can't meet and fines you can't pay. So we'll revoke your probation shortly and send you off to prison anyway. But for the time being, we'll at least make sure you don't ever vote again. So just that historical backdrop, I think, brings us to where we are today. In a system in which almost all the decisions are made by white people. 95% of all the elected prosecutors in the country are white. 78% of them are white men. My own experience, I can tell you that of those 78%, a very substantial percentage are very mean white men. And these people make the decisions that matter. This regulation of death, this notion that we're regulating it and now it's all going to be fair and all that, is all based about trials. It's all about how you try people. The two most important decisions made in every death penalty case is whether to seek the death penalty. There are many prosecutors who never seek the death penalty. And there are many prosecutors, like Johnny Holmes did in Houston, who would seek the death penalty at every opportunity to get the death penalty. And then the second one is plea bargains. And 95% of all death penalty cases are going to be resolved right there by plea bargains. And the choice whether to go for the death penalty. And we all know that race is all that matters in that decision. That when I can think of examples out of my practice, when my client William Anthony Brooks was accused of kidnapping, raping, and murdering a white woman in Columbus, Georgia, and everybody was out. Not only were all the police department people out, not only were the Boy Scouts out, everybody out searching for evidence, searching for whatever it could be. And then, of course, from the start, it was going to be a death penalty case that was presided over by a judge whose father had been involved in 2 prominent lynchings in that community. All-white jury tries the case and is clear from the outcome. The start, it was let the law take its course, and of course, they gave him the death penalty. When we were litigating the case later in post-conviction and pointing out that all the prosecutors, 10 out of 10, were white men, all racist. We couldn't prove that really, but I knew it for a fact, that were making the decisions about what cases were death cases and whatnot. But what we found was that when a white person's kid was killed, they'd bring them in. One fellow testified, I was called in by the prosecutor, and he said, do you want the death penalty for this guy who killed your daughter? And he said, yes. And the prosecutor said, that's all I need to know. That's all I need to know. Now, then we went to people in the black community, and far more. In this particular community, 70% of the victims of homicide were African American. And we went to those people, and they said, nobody even called us. They didn't even tell us about the plea bargain. And in fact, when I had the prosecutor on the stand, I said, did you know about the murder of John Brooks? That's William's father, who was murdered in Columbus, shot dead in a robbery. Did you think about going for the death penalty in that case? He didn't even know who John Brooks was. So there you see what's going on in terms of how race comes into these plays in a very realistic way. For the few cases that go to trial, as I said earlier, often by all-white juries. And the reason for that is because of the success of the prosecutors in striking people of color from the juries. I want to just take the last few minutes I have here and talk about this case that I had at the Supreme Court. It was decided last spring in May, Timothy Foster's case versus Chapman. This was a case in which it was tried the year after the Supreme Court had said in Batson versus Kentucky, we're going to stop this racial discrimination in jury selection by saying that any time a disparate number of people of ethnic group or gender are struck, you have to give reasons. And if the reason is race neutral, then on we go. Does anybody think that would possibly work? Could you be any stupider than to think that this is going to work? That the judge is going to be able to divine whether or not the people are telling the truth or not. Of course, the case before that, which deserves a quick honorable mention, Swain versus Alabama, 1965, Robert Swain goes to the Supreme Court and said, in the history of Talladega County, Robert Swain, an African-American, in the history of Talladega County, there has never been a black person on the jury. Now, Mike Radler was talking about pulling white balls out of a what's the likelihood that's happened by chance? Of course, the prosecutor struck everybody. And the Supreme Court said, well, that's a peremptory strike. I mean, that's wonderful. You can strike on the basis of race, religion, your hunches, all these things, unless you really just do it case after case. That's fine. As Thurgood Marshall said, an open invitation to discrimination. And then at Batson, they say, well, that probably wasn't such a good idea, so now we'll have people give reasons for their strikes. And the lawyers representing Timothy Foster, a couple of little country lawyers there in Rome, Georgia, but they at least did this. They filed a motion, and they said, the prosecutors in this county always strike all the blacks. They always have in every criminal case, not just death cases, all the cases. And they're going to do it in our case. And Judge, don't let them do it. There was a case decided last year by the Supreme Court, Batson versus Kentucky, says they can't do it anymore. And it was very interesting in the discussion, sort of the logistics, getting ready for trial. There was never any doubt that there was going to be a Batson hearing. You know, nobody suggested that maybe there wouldn't be any discrimination, so we wouldn't have a hearing about Batson. At any rate, the prosecutors then do, of course, strike all the African Americans, 4 out of 4, and then argue in closing argument to the all-white jury, give the death penalty to deter the people in the projects. Tim and his family lived in the projects. 90% of the projects were African American. Let me just go through, and the prosecutors did this when they were accused of discrimination. They said, we demand an apology. Not just that you apologize to us, but to the court, to this entire community for accusing us of race discrimination. That probably was pretty intimidating to those lawyers. Well, here was the file we discovered many years later. This is the first of many pages of the list of all the people summoned for jury duty in this case. You can see the ones where the arrows are highlighted in green. And there was a key up there you can't quite see at the top that said that meant black. But just in case you were colorblind, beside each person's name was a B. So you knew who the black, and this was circulated in the entire prosecutor's office, law enforcement, and so forth, that a race-coded list would be circulated to get some reasons to strike these black people. Then the black people are listed in these are the prosecutor's notes, which we got. I can't go into how, but we did. I mean, we open records act. I don't mean that. I just don't mean there's not time. B1, Eddie Hood, first black. B2 was Miss Wilson. B3, Miss Hines. Then we found this memo in there with all the black jurors are pulled out apart from the white jurors. And they write, if it comes down to having to pick one of the black jurors, well, maybe Miss Garrett would be all right. But Marilyn Garrett never had a snowball's chance of being on that jury, because here's their list of definite no's. And of the 6 people who are definite no's, definite strikes, the first 5 are African American. And as you can see, Ms. Garrett is number 4 there on their strike list. Ms. Garrett's here on their strike list. Ms. Garrett's here. Marilyn Garrett was never going to be on that jury. One of the reasons they gave for striking her was she was so close in age to Tim Foster. She was 36. He was 18. But that was only one of 12 reasons they were given. I've just got a couple more quick slides. This was their, they struck one juror, Eddie Hood, B1, because he was a member of the Church of Christ. And they said people at the Church of Christ are so adamantly opposed to the death penalty. I'm thinking, what church in the South has that attitude? Are so adamantly opposed to the death penalty that if you're a member of the Church of Christ, you're going to vote against the death penalty. Right there in the prosecutor's own handwriting, Church of Christ has no position on the death penalty, leaves it up to each individual member. And it's noted down below that it's a black church. And then I told you about the closing argument. And finally, I just say, this is what Marilyn Garrett said after the case was reversed. They just kept asking me over and over why I had 2 jobs. I was a single parent trying to take care of my children, that's why, and it irritated me. Got me in a defensive mode, and they said I was indignant. They treated me like I was a criminal. They had me in tears. It was really humiliating. This is how the black juror was treated. I'm going to skip Judge Sotomayor, and finally Eddie Hood has the last word. When I came home, I told my wife, more than likely, they're not going to want too many of us on the jury. This didn't bother the Georgia courts one iota. Didn't bother them at all. Only by the very serendipitous and lucky factor that the Supreme Court, for some reason, granted certiorari in this case, which was only sort of a one-off case in terms of why it was granted. It wasn't a great case today. It wasn't going to affect a lot of cases. It didn't resolve a split in the circuits or anything like that. If it hadn't been for that, the case would have gone into habeas corpus. He would have lost, and Tim would be executed. Only because the Supreme Court took it, and only because serendipitously we found this evidence through the Open Records Act. They meant to destroy it, I'm sure, after the jury selection, but they just forgot. And oops, that's what happens when you forget, just like in Philadelphia when they discovered a training tape in which they, the year after Batson, told everybody to strike on the basis of race. So race is such is the central factor, as Carolyn and Jordan recognize in their book, in the death penalty today. Thanks.
As was just stated in this wonderful book, the Stykers from first to last do put race as a central element in the story. And I would like to go to a case that raises the race issue. It's one of the few. One of the more interesting chapters in the Stykers book is Chapter 3, called The Invisibility of Race in the Constitutional Revolution. And they talk about the way in which, in cases where race is all over the case, the actual decision doesn't talk about race very much at all. But there is one case in which race is very central, and that's McCleskey versus Kemp. And a closely divided Supreme Court upheld a challenge to the administration of the death penalty despite statistical evidence strongly suggesting that race had played a systematic role in the infliction of capital punishment. And I wanted to ask the panelists and also the Stykers ex officio, they're always on the panel. I have 2 questions about McCleskey versus Kemp. One is, Justice Marshall was on the Supreme Court, but did not write in the case. And I've always thought it to be striking that in this case, the one case where the Supreme Court, in a plenary way, confronted the race question, Justice Marshall did not speak. And I've always thought, does anybody know why that was the case? Why is it? Or does anybody have speculation of why it was that in that case, Justice Marshall didn't say anything? I mean, he voted. He was part of the 4 that voted, but he didn't write, and I've always thought that's a striking thing. Second, why is it that McCleskey? There has never been a case in which a court has found a federal constitutional violation in a challenge to a death penalty. None. It always seems to me that it's in and of itself just a scandal. Given what we know about the United States of America, is it plausible to think that there's never been a constitutional violation? Seems to me clearly so, but no court has ever found a constitutional violation in a capital case. And I'd broaden it. I know of no case in which a court has found a federal constitutional violation to any penalty. And why is that? Now, the Stikers give a suggestion. They give us, they say, well, could it be, they speculate that maybe difficulties of proof insofar as these cases are generally based on statistical evidence, and that always poses a problem because there might be statistical evidence, but what about proof in this individual case? So there's the question of proof. Then there's the question, they suggest, of maybe anxiety over remedy, because if you were to find a constitutional violation in the capital area, well, what the heck? Beneath that, there's a whole lot of other areas. So, what do you do? Would this be opening up Pandora's box? And so maybe the court feels that it is an institution just cannot, wander into this territory. So they offer a reason, or how do people feel about those reasons? Is there some other thing going on? In any event, those are my two questions to the panelists and to the Stikers if they want to jump in.
Well, I do think that in looking at the cases, Justice Marshall obviously was one of the only people on the court, I think maybe the only person on the court that had any experience with actual capital cases. And he actually had made a lot of statements about the death penalty previously. He had a long opinion, concurring opinion in the Furman case, and then when the court changed its position in the Gregg case, he famously has this idea of the Marshall hypothesis, that if the public was just better educated about the death penalty, that they would not have, there'd be no support for it if people were educated citizens about everything that's going on, everything that we've talked about here today with race and the death penalty. It's just one aspect of that. So I know Brennan and Marshall famously dissented in, I think, over 2,500 cases, something like that, just relentless dissent against the death penalty. And we now have, a couple justices who are getting close to that, Justice Ginsburg and Justice Breyer, but I think everybody knew what his position was in the death penalty by then, at that point.
Yeah, I would agree. I think we have enough marshal clerks in the room that might be able to offer specific information on the answer to the question. In terms of why they haven't ruled on a case, I think they have erected, enormous barriers to bringing a case, and that can't be understated, right? In terms of bringing and marshaling evidence about intentional discrimination or systematic exclusion, or the role of race in the administration of capital punishment or any sentence, right? Armstrong and Bass create these rules that say you can't get access to the evidence that you need in order to make the case in the first place, right? You're barred at the first instance from bringing to get the evidence to show selective prosecution or so that kind of bias. And then you add it to what I was just talking about, right? Then they say history, which was also a part of the McCleskey presentation of evidence, right? They didn't just go with statistics in McCleskey. They went with statistics plus the history of discrimination in Georgia. And then the court says, well, no, we don't. That history wasn't good enough because it's too remote. So time and again, the court sort of erects these barriers to creating, to the presentation and the development of a case that it would even hear to allow you to get relief on those kind of those claims. So, I think we have been literally, hamstrung in terms of bringing these kind of cases. And that's why I think, when Buck or Foster are the cases that go to the court, it's because they're so explicit, right? It's because they're in neon lights. We are talking about racism, right? And you don't get to the other cases like the one I talked about, or the Heartland case of capital cases where race is the story, but it is not written down on a piece of paper.
And I would just say this, the one thing I'd add to what John said about when Marshall wrote his dissent to Furman, he was the one person who laid out the race. He was the one who pointed out that rapes in this country, that of 455 people, since Justice has started keeping statistics in 1930, of 455 people executed for the crime of rape, 405 were black. 405 out of 450, one of the most damning statistics. Nobody else talks much about race at all. And I think one of the great defects of the 76 decisions is you keep thinking, if you just tinker with the statutes a little bit, if you just do some proceduralism here, there, and yon, you're going to fix this. The problem was racism. And the problem was the pervasive racism in the prosecutor's offices and the way juries were selected and all those things. That was the ball game. And yet it's never even mentioned in those cases. And then it was alluded to earlier when Coker comes down and the court says in a where the victim was not killed, in a rape case where the victim was not killed, no death penalty. And you read that case, and nowhere in there is this 455, 405 statistic. Nowhere is there anything about race. If there was any reason to strike down the death penalty for rape, it was because of the racial discrimination which had gone back throughout the history of the country. And if you supplemented that with all the lynchings that took place for black men who looked the wrong way at a white woman, right up to Emmett Till, it would be an extraordinary figure. And yet we just never talk about that. And then the second thing on proceduralism, the other part of McCluskey, where the court talks about that all a state has to do is minimize the risk that race may have played a role. And so if you have this procedure and this procedure and this procedure and this procedure, you've done enough. Notice you never ask the question, did the procedures work? They don't work. So you have Batson. That doesn't work. You have Turner versus Murray. You can voir dire the jurors about, do any of you, ladies and gentlemen out there, have any racial prejudice? Raise your hand if you do. That's supposed to prevent jurors from being racially biased. Does anybody think that works? But so we're in this sort of fictional never land and saying we're not going to look and see, did it actually work? Was there race involved in the case? We're just going to say you've done all you have to do constitutionally. And that's the use of this procedural stuff to just completely hide reality, I guess, or I don't know how. It is to hide reality. And so somebody reads, well, there was no discrimination in this case, even though half the jurors used the N-word and whatever. This is Wiley Dobbs' case in Georgia. But the reason was not because there wasn't plenty of ample race discrimination. They called the defendant boy and by his first name and everybody else by their last name and all that. It's pretty rough stuff. But it was because the state procedures were sufficient to minimize the risk, even though they had failed miserably in that case to do it.
Can I just, is this on?
Yes.
It's on.
Just in my ex officio capacity, just on the question of Marshall. So McCluskey was decided the term before I clerked for him. I don't have any insight at all from the people who did clerk that year, but I will say that around that era, Brennan and Marshall were both in the dissent in a lot of important cases, with the exception of Steve Bright's first argument, my term in the court, in which Justice Marshall wrote the opinion for a 9-0 court in Amadeo versus Ann. But I will say in this era in which Brennan and Marshall were in the dissent in a lot of death penalty cases and other cases, Brennan's chambers he was a notorious dissent hog. He was, in terms of who gets to write dissents, the senior justice in the, dissent gets to, he was senior to Marshall, and his chambers would take a lot of the good dissents. And if you read, Brennan wrote a long and beautiful dissent in McCluskey, especially, I think, saying what I think Marshall would have wanted to say, which is he says, hey, let's just take a little tour of American history here and, do what we try to do in actually a much more cursory fashion in our book than Brennan does in his dissent in McCluskey, and talk about understanding racial disparities in capital punishment in terms of the history of statutes, black codes, lynching. And I just wonder what Marshall could have added to that. It would have been a little bit like Furman, where you read their two opinions and they're very similar, with the exception of the Marshall hypothesis. But they both have these long formulations of human dignity, which are very similar to one another. So that's my little thought. out what happened there. But
Yeah, my relation to the justice was as a colleague, not as a clerk. And one thing I learned from him was the intensity of his tactical thinking. His jokes were even tactical. If you just heard his joke as something to laugh at, you were missing something. And so I suggest that having a white man write that dissent is we don't know the answer to your question, but I think if you want to speculate, that's a fair way to go. That he thought it would be more powerful if Brennan wrote it than he did. And anyway, it's a marvelous dissent, so he may have been right.
That makes sense to me, but I would point out the other two justices, Blackmun and Stevens, both wrote dissents as well. So of the four, three dissented, and Marshall was the only one that did.
We have a little bit more. Others? Questions, comments, objections? Yes.
Yeah, just one very brief point about your point about no court ever having found a violation of racial discrimination in prosecution. Like, it's worth noting, given the apparent plans of the incoming administration to nominate Jeff Sessions as Attorney General, that there actually was a case where a court of appeals found sufficient evidence of racially selective prosecution to remand the case, and it was a case in which he was the United States attorney. It's a case called United States against Spiver Gordon from 1985, and so it might be worth people taking a look at that.
Others? Thank you very much.